Neighbour disputes can be incredibly stressful and can impact your enjoyment of your property. If you've not found any relief you want through QCAT or by peace and good behaviour order, then you may be able to commence legal action for nuisance and trespass. Nuisance is the unlawful interference with the person's use or enjoyment of land, or some right over it or in connection with it. Trespass is the direct, forcible and wrongful interference with the person or the person's land or chattels. If these elements can be made out, then you can sue your neighbour for compensatory damages, aggravated damages and potentially exemplary damages. If you successfully obtain a judgment for damages and the neighbour does not pay, then you can enforce the order by an enforcement warrant for seizure and sale of your neighbour's real property. What is private nuisance? There are various definitions that the court have found over the years. These include the unlawful interference with the person's use or enjoyment of land, or some right over it, or in connection with the land or right over it. Another definition is the unreasonable interference to the comfort or amenity of the inhabitants. To be successful in your claim, you must prove that you have title to sue. The neighbour has interfered with your property rights, and that interference was both substantial and unreasonable. In nuisance, liability is founded upon a state of affairs created, adopted, or continued by one person which, to a substantial degree, harms the other person in his or her enjoyment of their land. As a guide, by way of example, the courts have ruled on the following examples of private nuisance: continual surveillance by one neighbour on the other, filming the neighbours, threatening to kill the neighbours, threats of racial vilification and sexual orientation vilification. Private trespass can be split up in two different ways. Firstly, trespass to land, and secondly, trespass to the person. The elements of the cause of action of trespass to land are: the plaintiff is in exclusive possession of the land, the defendant enters onto the land or otherwise directly interferes with the plaintiff's exclusive possession of the land, the entry onto that land is a voluntary act or direct interference with the plaintiff's exclusive possession of the land is an intentional act. Trespass to the person is essentially assault, battery, or false imprisonment. The remedies for nuisance and trespass include injunctions or damages. If you obtain a money judgment, then you can enforce the judgment with enforcement warrants. Obviously, in relation to a dispute with a bad neighbour, the obvious choice is an enforcement warrant for seizure and sale of the neighbour's property. An enforcement warrant for seizure and sale of property allows you to lodge a writ on the title of the property and then instruct the enforcement officer or the bailiff to seize and sell that real property. Firstly, give you your judgment plus costs and interest, and secondly, remove the bad neighbour from their property. Nuisance and trespass can be used in some cases to compensate a neighbour for the bad behaviour of another neighbour. In some cases, you may be able to use the enforcement process to remove the neighbour from the property. However, legal proceedings for nuisance and trespass can be very complicated, and you should always consult with a litigation lawyer. At Stonegate Legal, we offer a free 30-minute consultation.